Hello, I'm Patrick Farnsworth. Welcome to Access and Privacy Online Commentary. Here's a prior segment from our weekly rundown. Fall of 2024 brings some interesting elections in Canada and in the United States. As a Canadian organization looking south, we are often faced with some challenging concepts and interpretations. Roe v. Wade was overturned 2 years ago, but impacts continue to resonate. There seems to be a never-ending stream of different news stories from states across the United States that report on ballot initiatives and legal challenges working their way through the courts that intersect women's rights, privacy rights, bodily autonomy, reproductive rights, and access to abortion. To make sense of it all, we contacted someone in our extended network with a great combination of cross-border experience and legal expertise in privacy. Cynthia Khoo is a technology and human rights lawyer and researcher based in Ontario. Cynthia, you were previously a senior associate at Georgetown Law's Center on Privacy and Technology in Washington, D.C., and during your time there, you co-organized a conference on abortion surveillance in response to Roe v. Wade being overturned in the United States. So let's start with the basics. Can you tell us why we keep seeing something that is a reproductive rights issue in Canada framed in what appears to be a privacy issue in the United States?
There's kind of a two-part answer. The first part is to do with how the right to abortion originated as a privacy right in the United States. And the second is why abortion is considered a privacy right today, even on top of that original framing. So to start with, it might help to understand how abortion is protected in Canada and then contrast it with how it's protected or was protected in the United States. The legality of abortion here in Canada is rooted in the right to life, liberty, and security of the person, specifically security of the person, which is enshrined in Section 7 of the Canadian Charter of Rights and Freedoms. Chief Justice Dixon in R. and Morgenthaler, which is the case that established our constitutional protection for abortion in Canada, found that the government forcing a woman to choose between carrying a pregnancy to term against her will or being criminally prosecuted for obtaining time-sensitive healthcare was a profound interference with someone's physical and bodily integrity, would endanger women's health, and would cause psychological and emotional distress, all of which amounted to violating her security of the person. In contrast, the United States took a bit more of a circuitous route to protecting abortion. It's less about the health dangers and the violative nature of denying an abortion to somebody who wants one, and more about protecting an individual's right to make a private decision without government interference. So that's rooted in the 14th Amendment of the U.S. Constitution, which protects the right not to be deprived of life, liberty, or property without due process. So the emphasis there by the U.S. Supreme Court is on the right to liberty, which was interpreted to include the freedom to make really personal and intimate decisions in private. Roe v. Wade actually came at the end of a series of cases about decisional privacy, all involving personal, intimate decisions to do with marriage, family planning, and contraception, for example. It's less about the importance of abortion access to the pregnant person's health, bodily integrity, and security of the person, and more about the right to make a decision about something as important as abortion. So that's how the right to abortion originated as a privacy issue in the US. But today, it's also become a privacy issue in a much more prominent sense in the way most of us likely think of privacy now, which is that abortion seekers and pregnant people's personal data and private messages are being exploited by technology companies, social media platforms, and data brokers in a way that aids and furthers the policing and criminalization of abortion that is spreading rampantly across the U.S. now in the wake of Roe v. Wade being overturned.
All right, well, thank you so much. That really helps a lot. Can you elaborate on what some of the key digital privacy issues around abortion today are, and then also provide some examples?
I would say that there are 4 major threats to privacy and the right to abortion due to the widespread sharing and selling of our personal data across the web. I should say that a lot of what I'm about to talk about is very US-centric, but maybe later on in this conversation, we can talk about why Canadians should care, even if a lot of this is happening in the United States. First, data broker companies sell pregnancy and abortion-related personal information in data sets that anyone can buy and thus endanger people seeking abortions or pregnant women. For example, two data broker companies, Placer.ai and SafeGraph, were selling location data at one point that showed where people who have visited abortion clinics live. They also predicted their demographics and showed patients travel paths to and from clinics. So you might be able to tell, for instance, if somebody had traveled from another jurisdiction. This information is available to the public. Anyone can access or buy it. So you can imagine how people who are opposed to abortion would use this information to target and harass women and pregnant people or even stalk them to their homes. This leads to the second major privacy-violating threat to abortion rights, which is anti-choice activists and religious fundamentalists using this commercially available data to target abortion seekers or people who are just looking for accurate information, targeting pregnant women and people, or medical professionals who are providing this healthcare. For example, in 2016, anti-abortion groups hired a company, Copley Advertising, to run geofenced ad campaigns on women entering abortion clinics. The ad system would know that you were there through your device, through location data, and start sending anti-abortion ads to your phone while you're at the clinic and for weeks after you left. So this same digital ad infrastructure that enabled Cambridge Analytica is the same one that so-called crisis pregnancy centers also use to spread misinformation about abortion, contraception, and reproductive health. Meanwhile, tech companies like Facebook actually facilitate and profit from a lot of this. In another instance, groups who were opposed to abortion and LGBTQ rights funded a women's fertility app, Femme, which collected reams of intimate data from its users while also spreading to them misinformation, endangering reproductive health and women's bodily autonomy. The third major threat that violates both privacy rights and the right to abortion is that the intertwining of corporate surveillance and state surveillance means that law enforcement can draw on our digital data trails to criminally charge or prosecute people who are seeking abortions, helping a friend or a family member with one, or who are providing an abortion. This had actually already been happening for long before Roe v. Wade was struck down, especially disproportionately targeting low-income women and Black, Indigenous, and other racialized women. But we'll likely see it spread and worsen as states in the U.S. increasingly criminalize abortion and implement more draconian restrictions and bans. So just to give some examples of how this can happen, in 2018, a woman named Latice Fisher in Mississippi was charged with second-degree murder after losing her pregnancy. So she faced up to 40 years in prison, and part of the evidence behind this charge was they pulled her search history. And 2023, in Nebraska, a woman named Jessica Burgess helped her 17-year-old daughter with a self-managed abortion. Police obtained their private Facebook messages, so they had a warrant. Facebook handed this information over, and in the end, the mother was sentenced to 2 years in prison, and the teenage girl who had the abortion was sentenced to 90 days in jail. Then going further back in 2015, a woman named Purvi Patel in Indiana was convicted and sentenced to 20 years in prison for a self-managed abortion. And how this happened is she had handed over her phone, so police were able to pull her text messages and email receipts. Last but not least, the fourth major privacy-related threat to abortion rights and reproductive justice is actually not from social media or period tracker apps or technology companies. It's from people. It's from the doctors, nurses, and medical staff who voluntarily report their patients to the police because they're suspicious or because they themselves are personally against abortion. This is what happened in Purvi Patel's case mentioned earlier. She went to the hospital for medical care, and an anti-abortion doctor called the police on her. So the important thing to remember about a lot of these cases and types of threat is that often no one who collected this personal data set out to violate or enable the violation of the privacy rights of pregnant people and abortion seekers specifically. The data was already there. It was already collected and packaged for sale because of the way that surveillance advertising works across the board and has been embedded into everything we do. So this is the other sense in which you could think of the right to privacy being tied up with the right to abortion and reproductive autonomy, because it is through these little day-to-day violations of our privacy that people who are against abortion get access to this personal data and are able to exploit it in order to go after pregnant people and abortion seekers and providers.
All right, so why should we care about these issues here in Canada if they are mostly happening in the United States?
I would highlight three main reasons that we should care about this issue in Canada, even if it's happening in the US. First, at the outset, it's important to note that the legal battles that abortion faces right now in the States is not our battle here in Canada. Abortion rights experts and feminist organizations have been very clear about this. Abortion has long been decriminalized in Canada and is regulated like any other form of healthcare under the Canada Health Act. So our issue is access, making sure that people who need an abortion can actually obtain one on the ground, wherever they live and whatever their income level, race, ethnicity, citizenship status, or gender identity, for example. How what is happening in the US impacts us from that perspective is that as women and people seeking abortions in the US are persuaded or tricked away from abortions, whether because they're given misleading or deceptive information or because they face potential criminalization, those who are wealthy and resourced enough may travel up here to seek their abortions in Canada, which puts additional strain on an already strained system. The answer, though, is not necessarily to turn away women who are seeking refuge from the United States, but is to ensure that we have improved access for abortion across the board, which is something that we should already have anyway. The second reason we should care is that the online anti-abortion and anti-choice tactics that we've seen in the US may be used to prey on women and pregnant people seeking abortions here in Canada as well. For instance, the geofencing tactic I mentioned earlier could be used to target people at abortion clinics, medical offices, or hospitals, almost amounting to a form of targeted digital harassment, even though physical harassment of patients and staff at these locations is illegal. We already know that misinformation about abortion, contraception, and reproductive health is rampant across online platforms in Canada, which is another known tactic. This is in part the work of hundreds of anti-abortion organizations and quote-unquote crisis pregnancy centers or pseudo-women's health clinics. We've been engaged in a national discussion for years now on how to regulate digital platforms here in Canada, most recently in the context of Bill C-63, which among other issues addresses tech-facilitated gender-based violence, and C-210, which addresses youth access to sexual material online. So in that regard, it should be noted that both Meta and TikTok have censored accurate information about abortion on their platforms. While several years ago, Google reportedly gave hundreds of thousands of dollars of free advertising to an anti-abortion group that was targeting women with deceiving ads. So to the extent that Canadians rely on these platforms, this impacts them in this way as well. The final key reason we should care is that seeing what's been happening in the US with respect to how important digital security and privacy has now become to people who might become pregnant or seek an abortion or those who care about and are trying to help them really brings to the forefront why it's important to protect privacy across the board, and especially the privacy of historically marginalized groups who are already disproportionately targeted by predatory surveillance. Protecting their privacy rights is critical to advancing vulnerable individuals' equality, autonomy, and self-determination, both within and outside of the context of abortion and reproductive justice. To that end, we need to act now to dismantle both corporate surveillance and state surveillance apparatuses that are collaborating with each other to erode away our human rights. This includes, at minimum, enshrining titanium-strength human rights-centered data protection laws, such as dramatically improving and then passing Bill C-27 and preserving end-to-end encryption of our private communications. If your personal data isn't collected in the first place, it can't be sold to data brokers who then sell it to anti-abortion groups who then exploit it to oppress women, non-binary, and trans people, and it can't be handed over to the police to be used against you in a criminal investigation.
All right, thank you so much, Cynthia, for joining us for this interview. Looking forward, we also know there's going to be a lot of ongoing research and monitoring considering the personal information of Canadians residing on U.S. data servers, and we look forward to the results of that. Access and Privacy Online reviews the headlines and delivers deeper commentary on a regular basis. Be sure to subscribe to get the full episodes every week and get notifications when we release show segments and other commentary throughout the week. We look forward to hearing from you soon. Have a good one.